have my homework upstairs.
May see the court session.
Good morning.
Good morning.
Morning. Okay. So, before we start talking about jury instructions, and for the record, the defendant is present, I took a look at the video last night, and the state provided me, basically it looks like a kind of a witness synopsis, and I'm not faulting anybody. It would have been more helpful to me as far as better instructing you all on what's coming in and out if there'd been an actual transcript that was timestamped so I could say with certainty, right. But it didn't happen, and it's, it is what it is. So, it's fine. I'm not blaming anybody.
Okay, all right.
I'm not. This is not a criticism. It's just, I'm just letting you know if I had a timestamp that I could have come in here and said, okay, defense, you need to take out, these are the specific portions, but I don't have that. Yeah. And it was a little difficult because the witnesses are kind of spliced throughout the video. So it isn't that you have one witness talking and then another witness talking. It's more broken up by topic from what I can tell, yes. Which made it a little tricky for me as far as trying to take notes as far as what should stay in and what should come out. So the bottom line is we're going to need to watch this together after we send the jury home. But I will say this, just a couple things that I know are coming out. The background music, that's coming out. Okay, there's no background music. I wouldn't allow the state of Florida to play a melancholy tune while the victim's family is up here testifying as to their loss, and so I'm not going to permit the defendant to have mournful tunes playing in the background. Dave the driver, most of his is coming out. From what I can tell, Dave the driver was just kind of driving around, generally talking about Kingston and the politics, and the vast majority of that is coming out. And really, at about 30 minutes, I think is where Dave the driver starts coming in. So I would say most of that is coming out. There is a photo vignette of the defendant's home and his neighborhood, and there was a photo of a dog. I don't know if it was a dog laying in the street or a dead dog, but I don't know why we have a photo of a dog. Also, the stepmother, she is Miss Arlene Richards, and most of hers is staying in, except for when she opines that the defendant had a bipolar disorder. She kind of makes an armchair diagnosis that's coming out. There's also a couple of the witnesses towards the end, when they're talking about Kingston, they're talking about the neighborhood and the garrison and the violence in the neighborhood. A couple of the witnesses gratuitously throw out about how the police come in and just beat people up or kill people. That's irrelevant. That's coming out too. Also, there's one witness who mostly talked about the defendant's mother and herself. Let me see if I can find her name.
Your Honor, I apologize that it was in a scribble format or handwritten. It's just
No one needs to apologize.
I watched it on Saturday and I wanted to get it to you as quick as possible.
Yeah. I'm going to have to watch it. There's one witness, I think her name begins with a C. Crystal something. I wrote it down. Oh, no, I'm sorry. Natalie Campbell. Basically, she talked about the defendant's mother being like her, and that she was a hard worker like me, and we all love our children, which she didn't, I don't think she mentioned anything at all about the defendant. So unless I see something different when we're watching the video, that's irrelevant. I had a question. So, who's Jason? Is there a Jason? No. No. Or maybe I was...
Jason Sabler?
I don't know.
He's on the last page. He makes some statements.
I think there's discussion as if they're referring to someone named Jason.
Yeah.
Which,
we need to watch it again, but I thought there was reference to a J or Jason, and then... So the defendant's nickname is or he goes by Trevor, but yet he has a brother, Trevor? Okay. I think there's a young man that
Trevor
speaks.
Jr.
Trevor Jr.
Yeah.
Right.
And then the father, because I know the father was killed, correct?
Correct.
So I was just trying to figure out who the players were. So there is a Trevor Ritchie that is in fact the defendant's biological brother, but the defendant nonetheless is also, at least allegedly, goes by the name Trevor.
Trevor and
Chino. Yeah.
When they were talking about Jason, Judge, I think it's one of the brothers that was gay, and he used to get a lot of beatings.
Yes.
Okay.
That's the Jason that you're talking to.
Okay. And I think that was in the context of the abusive father,
Right.
correct?
Yeah.
And most of that about the abusive father, even though it may not relate directly to Mr. Ritchie, it does show the violence in the household. So chances are most of that will stay in if it involves immediate family members that Mr. Ritchie, the defendant in this case, might have seen or been, had witnessed. So, but I had a little trouble understanding who some of the players were when the witnesses were talking. So maybe we can sort some of that out. So the first 30 minutes, most of that is fine, except for what I've referenced, the dog, the background music, the bipolar reference by the stepmother. The second half, a lot of that's coming out. Okay? So, anyway, but we will need to actually view it on the record so it's clear exactly at what timestamp moment stuff needs to come out.
There were portions that I noted where, all that's hearsay, but there were portions where people were talking about something they had heard about what had occurred in the house or what they had heard.
And that's fine, and as we're watching it, you can raise objections at that
Okay.
point in time, and we can discuss it further. And again, hearsay is admissible if the state has a meaningful opportunity to rebut it. So it just depends upon what the hearsay is, and we'll just have to address it line by line, basically. Okay, so that's that, and I do have, I'm going to have my JA make a copy of your original witness
Okay.
synopsis, because I did make some notes for my own reference, and then I'll give it back to you. Here is the DVD back.
Okay.
Sure. All right, so let's start going through the jury instructions. Okay, so I am going to instruct the jury first, all right, before closings. So actually 2.7 closing argument, I will read to them tomorrow morning before closings, all right? So any, that is the standard form, any objection or addition or correction?
No.
Okay. So 3.1, introduction to final instructions, that is where I will begin reading to them today. This appears to be the standard instruction. Any objection or requested correction?
No, Your Honor, you're going to instruct them today and then
Yes.
do the closing argument portion tomorrow?
Yes.
Okay.
Any objection?
No.
Okay. 3.2, statement of charge. Any objection or requested correction or addition? Okay. And I did just, in the statement of charge, I did use the defendant's full name, including his middle name. I did not use the middle name throughout. If you want me to put it back in, I can. It gets a little repetitive for me as I'm reading it, but if you guys really want the middle name in, I'll put it in.
It's fine the way it is.
Okay, all right. 3.4, lesser included. So with regards to the count 1, murder in the first degree, the lessers are murder in the second degree, aggravated manslaughter, murder in the third degree. Any other requested lessers from the defense for count 1?
No, Your Honor.
Okay. The lesser crimes included the definition of sexual battery, victim less than 12, defendant over 18. The state had originally just put in battery. I put with the question mark, lewd and lascivious battery, victim less than 16, and or aggravated battery. Is there any additional lessers that the defense is requesting for the count 2 sexual battery?
I would ask that those two be included, but nothing additional.
Okay. State, what's your position on that?
You have aggravated battery and battery, or is it Just,
Well, yeah,
Battery is the only category 1.
I understand.
the lewd and lascivious battery and aggravated battery are both category 2s, is that correct?
Yeah.
Okay.
Judge, there was a star by the lewd or lascivious battery. If I can just quickly look at that instruction, because typically lewd and lascivious battery is only victims 12 to less than 16. And so we don't have a victim that's 12. So if I could just quickly look at that.
Well, I guess maybe it would be lewd or lascivious battery. Lewd or lascivious molestation, but I don't know if that's a,
We didn't allege those facts in the indictment, though, Judge.
okay. So, looking at lewd or lascivious battery, 800.04 subsection 4A2. Well, okay, this is what it says. A person commits lewd or lascivious battery by encouraging, forcing, or enticing any person less than 16 years of age to engage in sadomasochistic abuse, sexual bestiality, prostitution, or any other act involving sexual activity. So does that apply to this case?
I think it could. Any other act of sexual activity.
Are you asking for it? We're not going to object if they ask for it.
Are you asking for it, Mr.
Yes.
Brightline?
And I don't think the fact's excluded.
Okay, that's fine. Then I will go ahead and give that. What about aggravated battery? Are you asking for that as a lesser?
No.
Okay, so aggravated battery comes out. So battery stays in. The lesser crimes included in the definition of aggravated child abuse are child abuse, and then I put a question mark as to battery. Are you requesting a battery?
I am.
Okay. Any
Judge,
objection?
just so we know, it says that battery should only be given if we charged it under the aggravated battery elements.
Wait, what count are we talking about?
The aggravated child abuse lesser for battery.
Uh-huh.
So it says you should only give it if we charged under, I believe, the 1A, which is aggravated battery, which we didn't. We charged it under 1E.
What's the, I'm sorry, what's the charging?
It's
What's the
16. You mean what number is it?
Yeah.
It's 16, I think, .1. Yeah, 16.1.
You're talking about the jury instruction?
Yeah. So if you look in the box under category 1, it says battery. If element 1A is charged, which is 1A is the aggravated battery, but we charge under 1E. And then it cites to the comma case, which is now negative, and comma now cites to Rayford. And if you look at Rayford, it deals with parental discipline and corporal punishment. So I don't know if that's appropriate, because those aren't the facts alleged here, but we would defer to the court. But I was just going to bring that to the court's attention, that typically that's only when you get the battery.
Are you objecting if the defense wants it in?
No.
You want it in?
Yes.
Okay, it'll stay in. All right, so just to confirm, the lessers for count 2, sexual battery, will be lewd and lascivious battery, victim less than 16, pursuant to statute 800.04, subsection 4A2, and battery. The lesser crime included in the definition of aggravated child abuse, those will be child abuse and battery. Okay. 7.1, introduction to homicide. Any objection or requested correction?
No, Your Honor.
Okay. You guys look at this last night?
I had, the way that it has or was, I had scratched that out, but either way is fine.
You mean under excusable homicide?
Where it says, no, under the introduction, where it says, killing was murder in the first degree, and then it says, or was murder in the second degree, or was, another way of doing that is just putting commas in between each of them, and then just have or was at the very end, but either way is fine. I think it's fine the way it is.
Yeah, that's fine. The way you have it is the way I've seen it before, Your Honor.
Okay. So we're talking about the paragraph that starts with, if you find Felicia Williams was killed by Granville Ritchie, correct?
Yes, correct.
Correct.
Okay. Well, I'll leave it as it is.
Yeah.
Any other requested corrections? 7.1, introduction to homicide.
No.
Okay. All right, 7.2, murder, first degree premeditated murder. Definition. Any requested correction or objection?
No, Your Honor.
That's fine.
Okay, 7.3, felony murder in the first degree.
So we're gonna add to element 2 and/or sexual battery victim less than 12.
Okay, while engaged in the commission of
We would like the sexual battery to come first since it's count 2.
Okay. Sexual battery. And you want that to be an and/or aggravated child abuse?
Yes.
Vince, what's your position on that?
Your Honor, my position on the felony murder instruction, and I recognize that this is inconsistent with the current state of the law in the state of Florida, but my position is because the state does not specifically list in the indictment the sexual battery and the aggravated child abuse, that it should not be an option for the jury and it should not be instructed on it. But I recognize that the law in Florida
It's contrary to that
is
position.
contrary to that position. I believe under Hearst and Ring and Apprendi that that's an incorrect position, but
All right, your objection is noted for the record. Is there any objection to the, because the sexual battery will come in as a qualifying offense for the first degree felony murder. Is there any objection to using the term and/or sexual battery, victim less than 12, and/or aggravated child abuse?
Your Honor, I believe that they should make the specific findings at some point, but that's
Well, they will
Yeah,
on their
okay.
verdict form.
That's fine. Then I
Okay.
don't have any
Okay.
other than my earlier objection.
All right, and then obviously the last sentence will change to the crimes of sexual battery, victim less than 12, and aggravated child abuse are defined later in these instructions. Okay. Murder in the second degree, 7.4, lessers to count 1. Any objection to that instruction?
No, Your Honor.
Okay. Okay.
Yep, that's fine.
Okay. Next up, 7.7A, aggravated manslaughter, lessers to count 1.
No objection.
I'm not sure that the facts support it, Your Honor.
Well, you guys included it.
I included an abundance of caution. I just don't know if he's going to qualify as a caregiver.
Well, don't know either.
That's fine.
Does defense want it in?
Sure. I mean, I agree that I don't think he qualifies as a caregiver, but
Okay. So, stay in. 7.7 manslaughter, lesser's to count one.
Do we really need involuntary manslaughter in there?
The defense wants it,
right.
Do you want it?
okay? So, I mean, what I guess we need to think about the aggravated manslaughter, because if for some reason this jury comes back aggravated manslaughter, then I don't want to hear post verdict that, well, there was no evidence to establish he was a caregiver, so that way it's got to be reduced. So,
And I don't see any evidence of neglect.
So-
That death was a result of neglect.
Well, let's take it out then. Let's just stick with the manslaughter, take the aggravated manslaughter out.
okay, that's fine, because I could just see a potential problem down the road.
I would certainly be arguing.
Yes, you certainly would be arguing that after you asked me to keep the instruction in. You would be arguing, oh, never mind, he was never even a caregiver. There's no evidence of that. So, state agrees and I agree, okay? So, I'm going to take aggravated manslaughter out completely as a lesser and from the verdict form, okay? So let me just make that correction real quick. Okay, so manslaughter stays in, felony murder, 3rd degree. So, what would be our qualifying offenses for 3rd degree felony murder? All right,
Simple child abuse,
and what about the
lewd lascivious
O&O?
battery.
Yeah, okay.
But with that mentioned first, listed first.
With what
The
listed?
L&L battery and or child abuse.
Okay, you agree with those?
Right, yeah. And or child abuse,
Yeah.
not simple child abuse, but just child abuse.
Just child abuse,
Right.
yes.
Third degree.
Right.
Your child.
Okay, so it would read, while engaged in the commission of lewd lascivious, was it battery,
Yes.
and or child abuse,
Right.
okay? And I could put in there, while engaged in the commission of lewd lascivious battery, and put in parentheses lesser count 2, and or child abuse lesser count 3,
I think that would be a good
just to
idea.
make it
Clarify.
clear what we're talking about.
Yeah, I agree.
Okay,
And you're doing separate and separately intertwined instructions.
I am. So we're gonna, but I need to add language in there about this 3rd degree felony murder. Okay, moving on. Any other requested changes from the state or the defense to felony murder 3rd degree?
No.
Okay. All right, sex battery, victim less than 12 years of age. Any objection or requested addition or correction?
Judge, in the indictment, we only alleged penetration. We didn't allege union.
Okay. You want to take it out, Mr.
Yes.
Krumbine? So 1A comes out and it just, I'm going to remove the B.
Well, no, 1A stays in
1A
as far
stays
as.
in, B goes out.
No, they both stay, so the only
Union
part that
comes
needs
out.
to come out is, and in the end part of 1A, it says, or had union with the
Okay,
vagina.
I'll take that out.
Or had union, so it just needs to be, Granville Ritchie committed an act upon Felicia Williams in which the sexual organ of Granville Ritchie penetrated
Right.
the vagina of Felicia Williams.
Gotcha. Okay, any other requested changes? Hearing nothing, take that as a no. All right. There will be, after this, 11.1 sexual battery, then I will add in the lesser of lewd lascivious battery. That instruction, so I'll have to add that in. Okay? And we'll discuss these one more time before, we'll take during our lunch break.
And Judge, for the L&L battery, you're just gonna put engaged in sexual activity, you're not gonna put
Correct.
sadomasochistic.
Right, yeah, just engage in sexual activity. Okay. All right, and then battery is the lesser, count 2. Okay? Any requested correction to that?
You wanna put lesser as to count 2 and 3?
No, because I'll throw in another battery when
Okay.
I'm talking about the count 3 lessers. Okay? All right, any objection?
No.
Okay. Aggravated child abuse, 16.1. Any objection or requested addition or correction?
Not from the state.
Wait on.
Okay. Child abuse, 16.3, lessers to count 3. Any requested correction or addition?
No.
Okay, and then after this, I'll put in another battery instruction, lesser to count 3, just so it's clear. Okay, 3.12A, single defendant, multiple counts. I added the last, in parentheses, the last sentence is, a finding of guilty or not guilty as to one crime does not affect your verdict as to the other crimes charged, except for legally interlocking counts, which I will now define for you. Any objection to that addition on my part? The standard instruction doesn't have that last portion. I just put that in there.
I thought I remember seeing that though at some point in the old standards or.
I don't know. I didn't see it. It wasn't in there in the original set you guys gave me.
Your Honor, my belief is that the standard is sufficient without the added language. The standard legally interlocking counts instruction will deal with the issues that you're addressing in the parentheses.
I mean, it's just a cautionary. It just is letting them know there's an exception, but
If counsel's objecting to it, Your Honor, I would ask for at least the bracketed language that talks about the interlocking counts, that be left on the end of the standard. Because I think otherwise it's confusing.
I agree. That's why I put it in.
Right.
Because I think because on one hand, I tell them a finding of guilty or not guilty as to one crime does not affect your verdict as to the other crimes charged, and then I turn right around and read legally interlocking counts. So which one controls? So that's why I included that little extra blurb, except for legally interlocking counts, which I will now define for you.
I can tell the court, I know Judge Fuente and Judge Battles both would put that in there, the interlocking counts language.
It just lets them know that this is the rule, but there is one exception to the rule. Okay, so
And my position remains the same, that it's sufficiently taken care of in 3.12D, and I'm requesting that you only read the standard 3.12A.
okay, well, I'll take a look at it. I think it is a correct recitation of the law, so I'm inclined to leave it in, but I'll look at it once again just to make sure there's not a problem with it. Okay, legally interlocking counts.
We're gonna add in the sexual battery.
Yes, and or sex battery count 2 are linked in that sex battery and or child abuse maybe we should use or here. I think as opposed to doing and or, we should just use or. All right, then the next paragraph, you should first consider the evidence applicable to sex battery in count 2 and aggravated child abuse in count 3. if you find either sex battery or sex battery or ag child abuse.
I think it'd have to be and there, right?
Yes, and.
Because it's
Right, it is and. Has not been proved beyond a reasonable doubt, then you must find Granville Ritchie not guilty of first-degree murder under the theory of felony murder. However, you may still consider whether the evidence established beyond a reasonable doubt the crime of first-degree murder under the theory of premeditated murder or second-degree murder, or take it out, aggravated manslaughter or third-degree murder. Does that be third-degree felony murder or just third-degree murder?
It's third-degree murder.
Okay. On the other hand, if you find that either sex bat, victim less than 12 in count 1, or aggravated child abuse in count 3 was proved beyond a reasonable doubt, you must then consider the evidence applicable to first-degree felony murder. A guilty verdict on either sex bat count 2 or aggravated child abuse on count 3 does not require a guilty verdict of first-degree murder under the theory of felony murder. You should find Granville Ritchie guilty of first-degree murder under the theory of felony murder only if you find all of the elements of that crime, including the essential elements of either sex bat or aggravated child abuse, were proved beyond a reasonable doubt. Okay, so we would then need to add a similar instruction for third-degree felony murder. Third-degree felony murder, lesser, count 1, and L&L battery, right? And simple child abuse and L&L battery.
L&L battery and child abuse.
Okay, and L&L lesser, count 2, and child abuse, lesser, count 3, are linked in that either of those is an essential element of third-degree murder. I put third-degree felony murder. Do you guys just want it third-degree murder? I think it explains it kind of better. They understand it's.
You say first-degree felony murder,
Yeah.
so
Yeah,
I think you say third-degree felony.
Yeah. Okay.
Basically cut and pasting that whole,
Yeah.
those whole paragraphs and inserting L&L battery and child abuse for the sex bat and ag child.
Right. I'll need to work on this, and we'll need to go over it again before we actually read it to the jury, because this one needs more work. So I will work on that. But that's basically what I will do, is replicate what's in the first part about first-degree felony murder to the third-degree felony murder. Okay. Okay. 3.7, plea of not guilty, reasonable doubt, burden of proof. This is standard instruction. Any objection?
No.
No.
Okay. 3.9, weighing the evidence. I didn't hear anyone having been convicted of a felony, so I didn't include that. And at this point in time, I didn't put in the defendant has become a witness, but if he does take the stand, then I'll put that back in.
Judge, the one that was missing is money or preferred treatment or benefit, because I think his evidence has the pending charge.
Okay, so I'll put that back in, put it in.
Another thing is Jeremicia was a child witness. I don't know if we want to include that or not.
Defense, do you want it?
Yes.
Okay, I'll put that in. Anything else?
That's all I saw.
Oh, yeah.
Okay. All right. Assuming defendant does not testify, 3.9A, that's the standard instruction. Any objection?
No objection.
Okay. 3.9B, defendant's statements. It's the standard instruction. Any objection?
No.
No objection.
Okay. Then, that's all I'm going to read today. Well, let me hold on. actually, I will go ahead, I'm gonna read 3.10, rules for deliberation. Any objection to that? It's the standard instruction.
No, Judge.
And I did take out, there is one, normally in paragraph 5, it says, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is my job as the judge to determine the appropriate sentence, but since the jury determines sentencing, I took that out.
Yes, Judge.
Okay? Any other objections or requested corrections to 3.10? Okay, 3.11, cautionary instruction,
No objection.
standard instruction. Okay? 3.12, verdict. Standard instruction.
No objection.
Okay? And then the verdict form is at the back of the packet. All right, so on the verdict form, we're going to take out aggravated manslaughter as a lesser. So then it will be A, B, C, D, E. And on A, it asks the jury, says check only A, B, C, D, or E, plus any special finding as to this count. A, the defendant is guilty of first-degree murder as charged, and check only 1, 2, or 3. 1, the killing was premeditated murder, or 2, the killing was felony murder, based on a finding of guilty of sex battery, count 2, or aggravated child abuse, count 3, or 3, the killing was premeditated murder and felony murder, based on a finding of guilty of sex bat in count 2, or aggravated child abuse in count 3. Correct?
Your Honor, I would ask that, because you have the offenses with capital letters, I would ask that not guilty and guilty also should start with
Okay.
capital letters.
Granted.
Judge, in the third interrogatory of count, or the A, defendant's guilty of first-degree murder, the state believes it should read based on the finding of guilty of sexual battery and or aggravated child abuse, because they could find one, the other, or both
Okay.
to support the felony murder.
Okay.
I can't do it.
All right, that's fine. I'll put
And
that in.
also in the second,
I see.
yeah.
Okay. The defendant's guilty. Let's talk about D. The defendant's guilty of murder in the third degree, a lesser offense, based on a finding of guilty.
Of lewd or lascivious battery and or child abuse.
Right. Okay. And then defendant is not guilty, and I'll make that a capital N and a capital G. Okay. On count 2, B will become L&L battery, lesser. C will be battery. D will be not guilty, and again, I'll make that a capital N, capital G. So we'll read check only A, B, C, or D as to this count. As to count 3 of the charge, the defendant is guilty of aggravated child abuse is charged, guilty of child abuse, a lesser offense. C will become the lesser of battery. D will become not guilty, and again, I'll make it capital N, capital G. And then it will read check only A, B, C, or D as to this count. Any other requested changes to the verdict form? Okay. All right, so then tomorrow, when we come back for closings, I will then read 3.13, submitting case to the jury. And then after the jury is then sent in to retire, and I let the alternates know they have to stay, I'll then read the dismissal of alternate jurors. Any objection or requested correction to 3.13, submitting case to jury, or dismissal of alternate jurors?
This is just a standard instruction.
Yep. You talking about 3.13, submitting case to jury?
No, the dismissal of alternate
As far as I know.
Okay. Yeah, that's fine.
Well, let me put it to you this way. when I went to the capital cases refresher course at the judicial conference, this is what was provided
Yeah, it was
as
fine, Judge.
something to use. So when you say standard, I don't know, I'll take a look to see if this is the exact standard in the,
Okay.
I'll take a look just to make sure.
It definitely recites the law. I mean, it recites what
Yes.
needs to be advised about.
I think it also just tries to make it more palatable for the alternate jurors who had to sit through trial but yet don't get to participate in deliberations. So I'll look it over. At this point, any objection or requested corrections to dismissal of alternate jurors, death penalty cases. Okay. And we can talk about penalty phase initial instructions, assuming we can get there. So I did provide that to you. That is the standard. I just printed it right up from the Florida Supreme Court website. So you guys have it, and hopefully you have a chance to look at it. But it seems pretty straightforward. Okay. Okay, so I'll work on those. Anything else? You want me to go ahead and colloquy with your client about whether or not he's going to testify?
Yes, Judge. And then when you're done, I'm going to need about 10 minutes to use the restroom and also to look at some exhibits.
Sure, and just let them know we're getting close, okay?
Okay, 10 minutes, 15?
I'd say 10 minutes. Okay. Okay, so Mr. Ritchie, we're getting close, very close to the point of the trial where you have to make the decision whether or not you wish to testify on your own behalf or whether you wish to remain silent. Do you understand that? Okay. And do you understand that the decision to testify or the decision to remain silent is yours and yours alone? Do you understand that?
Yes.
And do you understand no one can compel you to either take the stand and testify or compel you or force you to remain silent? Do you understand that? The state attorney can't make you do it. I can't make you do it. Your attorneys can't make you do it. You and only you get to make that critical decision. Do you understand? All right, and have you had sufficient time to consult with your attorneys about whether or not you should testify or whether or not you should remain silent?
Yes.
All right, and what is the decision you have made at this point?
Not testifying.
Okay, so you wish to exercise your right to remain silent. All right, and has anybody, including your own attorneys, in any way threatened you or coerced you or made you any promises on what you have relied upon in order to get you to make the decision to remain silent? Okay, and do you understand that this is the point in the trial where if anyone had coerced you or threatened you or promised you anything, that you would have to tell me about that? Do you understand that? All right, and did your attorneys discuss with you that if you were to take the stand, does he have any prior felony convictions?
No, Your Honor.
Okay, so then that would not be an issue for you. The state would not be able to ask you any questions. No one would be able to get into your criminal record or lack thereof. Okay, so that's not an issue. Has anyone, including your attorneys, made you any promises or assurances regarding what the outcome of this trial will be?
Say it again, ma'am.
Has anyone promised you or made any assurances to you what the outcome of this trial will be, what the jury verdict will be? Has anyone told you that? And do you understand no one can predict what this jury will ultimately do? Do you understand that?
Yes.
Okay. Do you have any questions or concerns about your right to testify or your right to remain silent that you need to ask me now? Okay. All right. I find that the defendant has made a knowing and voluntary waiver of his right to testify and is choosing to exercise his right to remain silent. Okay. Let's go ahead and take a quick recess, and then we'll be back.
Judge, I did have one quick matter
Yeah.
I will bring to the court. I know counsel has reserved his opening statement
Yes.
for his case, and I understand the strategy, and I'm not faulting counsel for that. I would move now, though, to prohibit the defense from arguing what's occurred in the case so far, or making arguments in their opening statement about the state's case. Opening statements are a forward-looking device in the criminal justice system to tell the jurors what they can expect to see. I don't think counsel should be talking about anything other than what's going to be in his case. maybe contrasting it, but not arguing what's been already presented. I don't think counsel should have a double closing statement in the next 2 days to the jury. So.
What's your response?
Your Honor, I'm not intending on making a closing argument. It is my intent to remind the jury that my client is presumed innocent, and that briefly touch on the fact that he did not commit these violent acts. And then I'm going to talk about the evidence that's upcoming, and I'll tell the jury that I'm not here to argue about the facts. That's for tomorrow. It'll be brief, but I think certainly I can remind them that he's presumed innocent, and
That's fine.
just like the state, I was able to point the finger and say that he's guilty.
Right.
And Judge, the only reason I bring it now, I don't like to object in openings or closings. I don't think it's good form, and that's why I wanted to address it now.
Well, I'm going to assume Mr. Granville is going to make a traditional opening statement without argument, and then if you feel he's crossed the line, then you can make the objection at that point. It does make it a little trickier because now the facts have come in, as opposed to it being a forward-looking, the state's facts are in. But as long as you're staying within the parameters of what the evidence is, then you should be fine.
Right. I mean, my intent is initially to say to this jury that he's presumed innocent. He did not murder Felicia Williams, did not sexually batter her, did not abuse her in any way.
Okay.
And then talk about the facts.
All right. Very good.
All right.
Okay.
I had a question from a juror. I told him better to ask the court than that.
Okay, and we did get a question from one of our jurors, Judge Sisko. I have a question about the potential for this case continuing into next week. Monday is the Jewish New Year, and I am scheduled to be part of the service. My understanding is court is closed on Monday. Can you please advise me on this? Thank you, Stephen Fisher. So I can tell them that I anticipate we're still on track to conclude this case by the end of the week, and that the juror is correct. The courthouse is closed on Monday. Nobody will be here Monday. Okay?
That's Judge, if they're going to deliberate Wednesday, hopeful that they'll reach a verdict Wednesday. If they go into a verdict Thursday, are we going to then start penalty phase Thursday afternoon? Is that the schedule?
Well, we'll see. Yeah, I mean, that's what we're going to have to do. You guys have to be ready to go Thursday
Yes, Your Honor.
with your penalty phase evidence, assuming the jury comes back guilty of first-degree murder. Okay? So you got to be ready to roll whenever it is. Okay.
You're going to ask.
I'll address it when they
Okay.
come in. Okay. All right. Couple minutes. We'll get going.